Thank you.
We'll see you soon, Mr. Palmer. If we could bring Mr. Williams out next, that'll be, I think, pretty quick. That way we can get Mr. Jacobs and Ms. Okam on their way. Ms. Okam, have you had a chance to speak with Mr. Jacobs about this case at all?
No, Your Honor, I officially started, what's today, Tuesday, so Monday.
Okay. Well, you two are going to get to know each other quickly. This case, and I'll repeat this when Mr. Williams gets out here, is one of my submissions to our consolidated jury trial calendar for early March.
Yes, Your Honor.
Everything okay? That's okay. We're not needing to take down right now, but are things okay or is something not working? Ah. It's not your job. Yeah. Okay. Yeah. Okay. Mr. Williams.
Yes, sir.
Good morning. You should be able to see your attorney on the screen. You see Mr. Jacobs there?
Yes, sir.
Okay. And there's a new prosecutor assigned to your case, Ms. Okam. You should be able to see her.
Oh, yes.
We put this on for a status hearing. I was giving your lawyer and Ms. Okam the update that I am putting this case on the March jury trial calendar that we are trying to stand up here in Fulton County. It's going to be a calendar with 1 or 2 cases from 3 or 4 judges. And this is one of the cases that needs to be ready to go as of March 8th, assuming the Supreme Court gives the green light to having jury trials around the state. Mr. Jacobs, was there anything you wanted to share? I know you and Ms. Okam haven't had a chance to connect on this case. You've been with the case from the beginning. Mr. Pinion and you, I know, had a number of conversations, and we stalled out for a little while on the question of experts, but then I authorized the release of funds so that you could retain an expert to evaluate all of the data that the I think it was the Highway Patrol had, whatever it's called here, had put together when they did their accident analysis and or reconstruction. Is that sort of where we left off?
Well, I apologize, Your Honor. I did not know you had released the funds. I didn't get an order on it, but I've got all the discovery ready, and they said they only need a week or so to look over it.
Well, good. You'll need to hop on it. Let me get on to Odyssey, but I don't know what we need to do to get things to you. I thought if something was e-filed, it went out.
I looked on Odyssey, or I looked on the clerk's website today. I didn't see an order, but I may not have gotten it, but I'll check my file, but I can get it to them very quickly and get it ready in the next week or 2.
Good.
I would like, obviously, to talk to Ms. Okam and see if there's a way to work this case out pre-trial. But a lot of that will be dependent on what the expert says, but I would certainly like to try to resolve this case if possible.
Sure. And you two are free to coordinate as much as you want. You have a little over a month, so that should be enough time. I'm calling the case up now. That's interesting. You filed the motion in September, and hold on. Someone dropped the ball. You haven't missed anything, but I did that order, Mr. Jacobs. I don't know why it's not in the docket, and that's frustrating. But I worked with court administration, and I did the order. It is not in the docket, so that will be fixed today.
Okay.
But you should assume that an order was entered that granted a certain amount of funding. I think there were two cases at the same time where folks were looking for county funding for experts. I think yours was, here's how much it would be to analyze the data, and there might be a second tier or tranche of funding if your expert needed to come testify at trial.
Yes, that's true.
I think the order green lighted the phase one, because
Okay.
as you've always pointed out, it could be that your expert looks at this and says, you don't want me to testify.
Yeah, absolutely. Yeah.
And so you need to do that part. We'll figure out what happened, but I apologize because I did that order quite some time ago.
Okay. I can get the discovery to them by tomorrow, and they should only need a couple weeks at the most to look over it.
Yeah, why don't you get them the discovery? I'll get the order out, and we'll see what's going to happen. Ms. O'Connor, do you have any questions or anything you want to add about Mr. Williams's case?
No, Your Honor. I believe Mr. Jacobs and I will have a conversation after this hearing is done.
Great. Sounds like a plan. Mr. Williams, you have any questions, sort of procedural? Obviously, you and Mr. Jacobs would talk privately about what's going on with the case.
No, sir, no question.
Okay, well, he'll be in touch with you. It sounds like he's going to be in touch with the expert who's going to look at some of the data in connection with the case. And Mr. Jacobs and Ms. O'Connor, please just keep Ms. Nelson posted. If this is a case that is going to resolve short of trial, we can get everyone back in here to take care of that. Anything else, Mr. Jacobs, besides please get you the order that I thought you got a few months ago?
Yeah, nothing, Your Honor.
Ms. O'Connor, anything else?
Nothing, Your Honor.
All right, well, it's very nice meeting you. I look forward to working with you. There is one other case that we're putting on the trial calendar that is yours. I'm blanking on the name right now, but you'll want to reach out to Ms. Nelson about that so you know what your top two will be.
Yes, Your Honor. Thank you, Your Honor.
All right, thank you. Welcome aboard.
All right.
Thank
Thank you very much.
All right, Mr. Williams.
All right, thank you.
So we may have our new, do we still call it CWAC or it's a different name now?
No, Judge, it's CAC. We're CAC now. We're dropping the W. We're just CAC.
Okay.
And I am actually not going to be the assigned prosecutor. It will be Siri Patel, but I am standing in for her today.
Okay, I was told it was going to be Ms., and I may mispronounce her name.
Miss Baisha's domestic violence. She's not crimes against children. And I believe the case that appears on the calendar that my name is on is crimes against children.
Got it. Okay. So many different lanes out there. Well, Ms. Beja,
We'll get you a roster, Judge. We'll get you a roster.
A roster would be helpful. So, Ms. Beja, you would be handling a stalking case or a felony family violence battery, that kind of thing?
Yes, Your Honor, I will be.
And
your
what
court
if
part is-
the allegations were that it was a boyfriend who raped a girlfriend? Would that be domestic violence or that would be CAC?
That raped a girlfriend?
Yes.
That's DV.
Okay. So it's not driven by the charge, it's driven by the relationship between alleged victim and alleged perpetrator.
Correct. I mean, crimes against children is pretty straightforward. If it's a child basically under the age of 16, it's coming to me.
Got it. But if we're dealing with adults, then we can't, if it just because it says rape doesn't mean it would be Ms. You said it's Siri Patel?
Siri Patel. You know
Okay.
Siri from MacGyver.
Okay. Yep. I didn't know she was still around. That's great. All these
She
folks
is.
who've been in sort of hibernation over the pandemic. Okay, that's great. A roster will be helpful.
Yes.
And Ms. Beja, it's great to meet you. I'm Judge McBurney. Welcome to this division.
Thank you, Judge McBurney. Great to meet you as well.
How many other divisions are you assigned to?
I'm assigned to 4 court parts. Yours, Judge Ellaby, LaGrua, and Judge Millender.
All right. Okay, that should be pretty smooth for you. And then Siri Patel is assigned to which courts, Ms.
She
McCauley?
has Millender, McBurney. Well, I'm going to go to my notes because I just did it. Judge Edwards and Judge Whitaker.
Okay, great. You are going to handle Ortega Ramirez for today because I don't
Yes.
see Ms. Patel.
Yes.
Okay. And then we have another Ms. Patel sitting right here. That would be Defense Counsel Patel, who represents Mr. Ortega Ramirez. And we can bring him out in a minute. I don't know that we have an interpreter, and I wasn't sure what we were doing today. We can certainly get someone here this morning. We might order that person up while we're doing our motions hearing. What was your thought we were doing today?
So I think it might be best to reset this. The purpose of it being on the calendar was to discuss how logistically we have a trial given the number.
Let me stop you for a sec. Are you, Ms. McCauley, are you able to hear Ms. Patel? She's not near a
Yep.
microphone, but if you can hear her, she doesn't need to move.
I hear her.
Great, keep going.
The number of interpreters we would need in addition, whether the state was going to translate the written statements as well as an interview that were conducted in Spanish as well. And so it seems like it would be a conversation we should have with Ms. Patel in the future once she has the opportunity to review the file.
Okay, and so I
Actually-
understand that last point you made. Your client gave a statement, that's all in Spanish?
No, one of the state's witnesses gave a statement that is an interview statement that's all in Spanish, and then that same witness had a written statement, and then another witness had another written statement that's also in Spanish.
2 written statements, 1 recorded interview, all in Spanish. And your question is, does the, state intend to have those translated so that they'd be accessible to a jury?
Correct, and just in the event that the state does have to refresh recollection,
Mhm.
anything like that, normally the state translates, provides a copy, we get a translator to look it over just to make sure it's
Right.
accurate.
Okay. It seems like, yeah, we could have that type of back and forth without bringing your client over to work through that. Is it trial ready from your perspective, apart from working through those dynamics? In other words, you're not missing discovery,
I don't believe there's any discovery that I'm missing at this point.
and there are no motions out there that I haven't ruled on.
No motions that I'm aware of. I don't intend to file any other than just any potential motions in limine.
That's fine. We would deal with those at the appropriate time. Okay. Well, we've got time to work through that because we're not putting CAC cases on our early jury trial calendars. But we do need to get this one ready to go. So why don't we, I'll have Ms. Nelson reach out to Ms. Patel from the state, as well as you, Ms. Patel, Mr. Ortega Ramirez's lawyer, to see if we can work through how many interpreters would we need. We need a number of them to always be translating for your client, and then a separate number of them to be translating for however many witnesses would be testifying in Spanish. And they cannot be the same crew,
Correct.
is my experience. Okay. Any other, so I see that as 2 logistical pieces, these state exhibits and translators.
Just the last thing was that I know that Ms. Pod was waiting to talk to the complaining witness in person, and COVID, complaining witness currently resides in New York. And that was just a huge barrier in terms of a potential resolution, because she was not able to have that face to face. So I just need to catch Ms. Patel from the state up about that last step.
Okay.
So.
All right.
So I'll chime in. I've made a note of everything that needs to happen. I'll touch base with Siri and just let her know about the statements and touch base with Ms. Hodge to make sure that that was put in motion and that we have the capability to do that. And then as your Ms. Patel, who's currently in the courtroom, if you could, I'll touch base with you and Marshall and Sari to kind of close the loop as to what the last discussions were regarding resolving the case. And we'll try to set something up with the victim via Zoom or on FaceTime so that we can have that conversation.
That sounds good.
Great. Okay. Excellent. We don't have a way to communicate particularly meaningfully with Mr. Ortega Ramirez. We can get an interpreter up here so you could have a 2-minute with him. Should we order someone up? And just when he or she arrives, you can chat briefly with him, or?
If that's possible, just so that he's not confused as well.
Sure. Okay. Ms. Nelson, can you see if we could get someone to swing by at some point this morning?
Yes, sir.
Thank you.
Mhm.
Did we not order someone up since he's on the calendar?
I thought that the attorneys were going to discuss what they needed on interpreters. I did not order anyone, but let me reach out to them and see if they can.
Okay, that'd be great. I guess in the future, if we're bringing Mr. Ortega over here, we probably ought to have an interpreter over here as well.
All right.
Thanks. Mr. Reed, then, I think is the last one other than Mr. Bush. And he can be at the doorway in just a minute. What I've got here is that we needed to figure out if a lawyer had been assigned, a C3 lawyer. So your office must have conflicted off. I don't mean to be looking at you if it would have been Mr. Franklin's case, but the public defender's office is not representing Mr. Reed. Maybe because of co-defendants. Yeah, he's got co-defendants. We just need to get this guy a lawyer who would be in a. Are you here for Mr. Reed?
Yes, we've been talking with attorney Roderick Bridges since last year, and it's the second court date. The first court date, the attorney did not show, and then he said he was going to be here on today, but he told our family that he would be here on today and to call him next year, which would be this year. We talked to him in last year, December, because no one showed. And we sent him a character reference letter to him so he can give to you. And so his name is attorney Roderick Bridges.
Sure, I know Mr. Bridges. Have you retained Mr. Bridges? You've given him money or?
He said that he was appointed the case because there was another attorney, which is, I can't think of his name right now, that originally had it.
Mm-hmm.
And then he got the case and he said that's why there was no attorney there. And when I spoke with him in December and my family, he said that he was going to be looking at it at the beginning of the year.
Let's look. Yep, it says Roderick Bridges right here in Odyssey.
So we wanted to ask him, is it going to be a bond hearing or a census hearing? He wasn't really sure, but we sent a corresponding.
He filed an entry. Yep, substitution of counsel. So you are related how to Mr. Reed?
His grandmother, I'm his auntie, also representing his mom, who's been on first responder, but she's in New Orleans doing nursing for the COVID cases.
Okay.
So I'm representing, I'm his aunt. and
Okay.
his mom.
So your nephew is represented by Mr. Bridges. He's filed paperwork to that effect. So I will have Ms. Nelson, who you can't see, but you can hear, reach out to Mr. Bridges' office to see when he's going to be down here because his case is on our calendar. Yes, ma'am.
Because he's been announced as October 31st, and he has no bond. So we trying to find out to see, can we give him a bond?
So the way that would work is Mr. Bridges, the lawyer, would need to file a motion requesting bond, and that would give the state a chance to be ready for it. And then we would have a bond hearing where Mr. Bridges would be able to share with me why your grandson is a good candidate for bond. He does have 2 cases. That always makes things a little more complicated. But he'd make his argument, the prosecutor would make her argument, and then I would let you know what's going to happen. Either I'm not changing anything or I do set a bond, but he's certainly entitled to a bond hearing. He just needs a lawyer for that to happen. And the first time I worked on the case, we were trying to figure out who that lawyer was. That's been answered. Mr. Bridges, he's filed his entrance. So we need to get him here. Ms. Nelson will reach out to him and let us know what the report is. So I'm going to keep Mr. Reed here upstairs. At a minimum, I'll let him know what's going on if Mr. Bridges says, oh my gosh, I forgot. And then he's going to tell us what day very, very soon he can be here so we can get Mr. Reed back here or on a Zoom calendar from the jail to figure out what's going on with the cases and if Mr. Bridges files it to handle the bond motion. Okay? Pardon me? Well, hopefully Mr. Bridges will show up today. I don't know that we'll talk about bond today because he hasn't filed a motion. And so the prosecutor is not necessarily in a position to argue about the case because she didn't know that we'd be talking about bond today. But if Mr. Bridges shows up, they can have a conversation and we'll see what happens, okay? But
A reference letter to you, you send it to him.
the best way is to get it to the lawyer, and then at the appropriate time, he'd share that, not just with me, he'd have to share it with the state as well. So you've done the right thing if you got it to Mr. Bridges. Now we just need Mr. Bridges to do the right thing and come on in, and we'll go from there. All right, so we'll hold on that. Ms. Nelson, you'll try to reach Mr. Bridges? We'll take that as a yes. And let's talk about Mr. Bush. Mr. Franklin is here. Did you all want to say something before we brought Mr. Bush out, or should we just bring him out?
You can bring him out.
Okay, are you ready for him? Great.
Judge, can I, may I be excused?
Yes, ma'am. Thank you for plugging in. We look forward to that roster of attorneys and units and all that kind of stuff.
I'll send you the one for CAC today. I'll send it out today, and then I'll follow up with everybody else, make sure we get a formal roster out.
Great, thank you. I'm frustrated about that order. The money was available long ago. Oh, that's good. Mr. Endurin says that the voice sounds good. Of course, my voice always sounds good, but it's audible. All right, Mr. Forte, are you ready? Let's go on the record in 20 SC 174805. It's State versus Ja'Cory Bush. Good morning, Mr. Bush.
I apologize. The last move.
All right. Everyone okay over there? All right, let's try that again. Good morning, Mr. Bush. Mr. Bush, your lawyer, Mr. Franklin, has filed 2 motions on your behalf. One of them seeks to suppress a statement that you may have given to the police when you were arrested. and the other seeks to suppress evidence that was seized from you. Sounds like this was all in late January. It's about a year ago, a year and a couple days ago. We're gonna try to work through, I think, at least one of those motions, but I want to let you know why we're here. Mr. Franklin, are you ready to get started?
Yes, sir.
Great. So Ms. Hall, you mentioned before Mr. Franklin got here that you're ready on one of the motions, but not the other. So let's make a record of that.
Yes, Your Honor. Actually, the first motion, the motion to suppress, Your Honor, I subpoenaed two officers, Officer Daggerin, I'm sorry, officer, who's present, and also Officer Douglas, who isn't present. We hadn't.
Can you spell the first officer's name for the record?
Yes, D as in David, A-G-R as in Robert, I-N.
Okay.
And the second officer is Officer Douglas, which I needed both officers for this first motion to suppress. Officer Dagger, he was the initial officer. And
when there are two motions to suppress, so which one are you talking about?
I'm sorry, the motion to suppress the stop of the defendant.
Okay.
The search and the stop of the defendant. I needed both officers for that. We hadn't heard back from Officer Douglas, but he called me late last night and told me that he hadn't received the subpoena because he's on FMLA. He and his wife just had a baby, so they're dealing with that. He is the sole officer for the second motion, so I was going to ask for a reset for that motion. I think we will be able to get through the first motion with Officer Dagan, even though he wasn't a part of the actual arrest at the end of the fleet. I think we'll be fine without Officer Douglas.
Okay. Well, what we'll do is at least go forward with the motion to suppress the fruits of the search and seizure with Officer Dagrin. And if at the end of his testimony, direct and cross, you feel like the record is not sufficient and want to keep it open for Officer Douglas, we can talk about whether that ought to happen. And it sounds like regardless, we'll need to get everyone back here because only Officer Douglas could talk about the statement that Mr. Bush gave.
Yes, Your Honor.
Okay.
There were several statements. I was going to talk to defense counsel to figure out which statements we are referring to. So there were multiple officers on the scene, and then there were also statements made at the headquarters. So I wasn't sure which statements. So I was subpoenaing more than one officer for that, but I'm pretty clear as to which one he's referring to. So that is just Officer Douglas. If we're referring to that one statement about him being in possession of the drugs.
Well, what the motion says, which is what you need to go by under paragraph 2, is that there's a theory that the state would attempt to introduce an oral admission to Officers Douglas and Skidmore while in custody. So if those are two different interviews, then you'd need Skidmore as well. If it's one interview, but Douglas and Skidmore were the two officers asking questions of Mr. Bush, then you may be fine with just one officer. I don't know the situation, but please do check with Mr. Franklin because he's entitled to try to keep out anything and everything, and you need to make sure you're addressing each of his concerns. So if there's a trial in this case, you're not surprised when you say, well, now I'm going to have Skidmore come testify, and Mr. Franklin says, well, no, that was one of the things I tried to keep out.
Yeah.
All right, Mr. Franklin, anything you want to talk about procedurally? It sounds like we have one of the officers who was involved in the search and seizure, Officer Dagrin, and he's prepared to testify. And we'll probably need to take everyone's pulse when he's done, because you may think that the record's not complete. You may want to hear something from Douglas or Skidmore. His name pops up in your other motion as well. Certainly you're entitled to that. And you wouldn't have thought to subpoena either of those officers if you were reasonably assuming that the state would bring them in. So are you all right if we proceed at a minimum with Officer Dagrin's testimony?
I'm weighing it since I'm hearing it. My initial thought was that I believe this is a rescheduled motion. We had another date, would have been December, or I'm not certain exactly when it was. So being that it's the second date that we are supposed to be handling this, and we are at least unable to handle some portion of it, the argument I'd probably make is that the motion be granted in our favor, being that we didn't hear about this particular issue until right before the motion started. As it pertains to the motion that I think we're able to go forward with, the motion to suppress the actual physical evidence, the marijuana, and to challenge the stop. I'm fine with going forward with that. But to be completely forthcoming, if the state doesn't have the other half of it, other officer, then it may be a disadvantage for them, and I would still be asking for likely a ruling to be made.
Okay.
with today's evidence as opposed to doing it piecemeal.
In terms of the Jackson Dental motion that you filed, is it your understanding from your review of the evidence that Officers Douglas and Skidmore jointly interviewed your client, or are there two separate
As I
encounters?
recall, Your Honor, I'm challenging, when he was taken into custody in the field, I believe Officer Skidmore was present at that point in time, or was referenced to have been present. So that's what I was challenging. I'm trying to recall if I recall seeing or receiving the custodial statement. So I'll speak with Ms. Hall about that
Okay.
portion stuff. But
And you're not waiving that? I mean, if it turns out that there was a down at the station house interview that you also have a concern about, we can work through that, but that would be another reason to reset. So we'll have to figure that out. Okay, well, we've got Officer Dagrin here. Let us use his time wisely. So if you want to call him to testify, we can see what we're going to do.
Thank you, Your Honor. Your Honor, the state calls Officer Dagrin to the stand. Your Honor, are we still having a motion at our tables?
It's up to you. You can be at the podium, but you are welcome to stay right there. If you are more comfortable staying seated, you can be heard just fine there. There's not a prohibition on using the podium if you want to. There's not a requirement to use the podium.
Thank you.
Sure.
Raise your right hand. Do you swear or affirm that the testimony shall give to the court the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You will also just state your name and spell it for the record.
My name is Officer P. Dagrin, first name Pierre, Pierre, last name Dagrin, Dagrin.
You can be seated. Thank you.
Good morning, Officer Dagrin. How you doing today?
All right, man.
Where do you currently work?
Zone 5, Midtown, Atlanta Police Department.
And how long have you worked there?
Midtown just started a couple months ago. Zone 5, Footbeat, I worked there for almost 2 years.
And were you assigned to Zone 5 back on January the 29th of 2020?
Yes, I was.
Okay. And were you post-certified?
Yes, I am.
What were your duties with Zone 5?
We're patrolling the Broad Street, Peachtree Street, 5 Points area, a lot of drug sales, homeless. That's pretty much what we're doing. We're Footbeat, so we knew everybody by name pretty much from the encounters we've had with people.
And the Footbeat means you were walking patrol?
Yes, we're walking. Sometimes we have a car too that we get from the precinct to our area. So sometimes we'll park the car and just walk all up and down the street, or we will just patrol in the car too, depending on how we were feeling that.
Were you doing foot patrol on the 29th of January 2020?
Yes, and vehicle patrol as well.
Yep. Do you remember where you were when you located or you encountered the defendant?
Yes, I do.
Where was that?
I was at the intersection of Peachtree Street and Trinity.
And is that in Fulton County?
Yes.
Were you wearing a body cam that day?
Yes, I was.
And did you already know the defendant before encountering him on that particular day?
Yes, I've encountered him a couple of times before, both for marijuana stops and arrest, as well as fleeing.
Okay. Did you have, when you saw the defendant on that particular day, what did you do?
I exited the vehicle, parked the vehicle on the street, walked out, initiated my body cam before I walked out. Walked out the front of the car. He was walking with another guy named Mr. McKenzie, who we also know. I said, "Hey, Mr. Bush, let me talk to you for a minute." And then he decided to just he backpedaled, mumbling, "Why are you trying to talk to me?" And then just ran into the street.
Okay, so when you said that when you approached or you saw him and encountered him and Mr. McKenzie, and you said, "Let me talk to you," was he detained at that time?
No, he could have just kept on walking and there would have been no problem.
And if he had kept on walking, would you have insisted that he spoke with you?
No, because I had no reason, just wanted to talk to him, general citizens encounter.
What was the reason for you wanting to talk to Mr. Bush?
Well, the reasons I wanted to talk to him before, I've gotten several people who have been telling me that after we leave, which is me, the football union in general, because we're down there so heavy and they don't expect that they know we're there and they don't know where we're coming from when they see us, that he and his other friend, Mr. McKenzie, were out there pretty much committing robberies as well as other crimes against people when we left. When our tour of duty was over, that's what I was getting from people. So I was just wanting to just talk to him, just random talk to him. And if he decided to walk away, I would have just left him alone.
So when you said you had been getting reports, was he a subject in any type of robberies or any of the complaints that you were receiving?
Objection relevance.
Your Honor, I'm asking because I'm trying to establish the purpose of the officer wanting to even have any type of conversation with the defendant, and whether he was a suspect at the time is important to whether he would have been detained or if he was free to leave.
He's already stated that he heard people say that he was involved in some robberies and he wanted to talk to him.
Okay, I agree. What I heard your question to be is, well, what type of robberies were these? And I don't know how relevant that is. Maybe I misunderstood your question, but what I've heard Officer Dagrin say so far is, I saw Mr. Bush, person of interest to me because of all the things the Officer Dagrin had heard about what happens when he and his partners are done with their shift. So that's why I approached Mr. Bush. So I was suspicious. I had heard he was robbing people, et cetera. I thought your question was, well, what kind of robberies? If that was your question, you need to explain to me how that's relevant. You know, good robbery, bad robbery. He's a suspect because he's allegedly robbing people. If I misunderstood your question, ask it again, and then I'll reevaluate the objection.
Yes, Your Honor. Well, my question was he a suspect at the time? Not just a person's interest, but someone that the department had been looking into, not just hearing stories, but actually looking into as a suspect. That was my question. Was he an actual suspect? I didn't care about what kind of crime it was, but if he was a suspect.
Okay, and the objection, Mr. Franklin has renewed the objection of relevance, and I overrule that. So if your question is sort of shades of meaning, but not just person of interest, was Mr. Bush a suspect in something that APD was looking into? You can answer that question, officer.
No, he wasn't.
Okay. Thank you. So when you encountered him and asked him if you could speak with him, you said that he kind of hesitated, shifted back, and then went into the street?
Yes.
When he went into the street, did he go on the street and come right back onto the sidewalk? Did he go across the street? What did he do?
He backpedaled on the sidewalk, looked at me, dashed across the street, stayed in the middle of the street, a Peachtree Street, heading north or south on Peachtree Street, then bent the right, heading west on Trinity, still in the middle of the street. Then he cut across Forsyth, that street, into a parking lot, went through the parking lot, cut across the intersection of Ted Turner and Trinity again before and jumping over the wall where there was the construction at.
When the defendant was in the middle of the road on Peachtree Street, were there any vehicles on the road as well?
There were vehicles that were passing by, but the whole time he's passing by, running down the street, there's vehicles stopping, because I'm also driving on the street as well, so I have to make sure I'm paying attention to everything else.
Right. Before you got in your car to pursue the defendant, he was still in the middle of the street and cars were there trying to avoid.
Yes.
Leading. Motion strike.
We don't need to strike it, but you need to rephrase your question.
Yes, Your Honor. When the defendant was in the road and he was fleeing from you, were there any cars initially on Peachtree Street that, I know you said that there were many, but initially on Peachtree Street, were there any cars that were driving while he was in the middle of the road?
I can't say there were, I didn't notice, but in passing there may have been, but the camera caught everything. I was solely focused on him and making sure that I don't wreck into anybody while I'm following him in the middle of the street.
And at this point, when you were pursuing the defendant, was it still for the initial conversation, or, I'm sorry, what was the reason for you pursuing the defendant at this
Once
point?
he darted into traffic, that's why I went after him.
And was the defendant eventually apprehended?
Yes, he was.
Can you tell me about some of the interactions that you had with witnesses during the pursuit of the defendant?
Okay, after he jumped the embankment, I looked down and I saw the security guard who was patrolling that construction area. He told me, "Yeah, are you looking for a guy in black?" Which I described as, "Yeah, he just ran through here, through the gate and on the railroad tracks." Then that's when I started to look down the road and I see him. And then that's when Skidmore and all the other people who were already canvassing the area, they knew how to get down there, which is on the other side of the street and through the other gate. And they followed him all the way through until they caught him.
When you interacted with this construction person, were you still in the car or
No.
are you now on foot?
I had already stopped at that intersection of Trinity and Ted Turner where he jumped. So now I could stand there and see across clearly.
And was that where the defendant was eventually apprehended?
No, he was apprehended down the street because he had a good start on us, which I had to drive from that location onto Peachtree Street down where the food production place is, Whitehall, where they changed to Whitehall. And that's where they brought him out from. So he ran quite a few ways.
Were you there when the defendant was apprehended?
Not when he was where he was caught at. No, I was out in the front where they brought him out of, where Skidmore and Douglas brought him from.
Do you know if any drugs were found on the person of the defendant?
Objection calls for hearsay.
Overruled.
I believe he had marijuana on him when they brought him from where they caught him from. And I searched him there. He had marijuana on him there.
I'm sorry.
So I want to make sure I follow that. You were not present when Mr. Bush was taken into custody, but Skidmore or Douglas or someone brought Mr. Bush to where you were.
No, where they were. I
You went to them.
drove back there when they brought him from the back onto the main street.
But at some point, you are reunited with Mr. Bush.
Yes.
He's in custody by then.
Yes.
Are you the one who patted Mr. Bush down and searched him?
I patted him down I assisted in pat down for where the marijuana was found.
Okay, I wanted to, so it wasn't that the officers said, we found this on Mr. Bush. You were there when whatever
when the
was
marijuana
found.
was found, yes.
Okay.
Do you know if any other drugs were located?
Well, from the state, as we were talking to Mr. Skidmore and Douglas, they say they also found a vial with suspected crack cocaine not too far from where he was actually apprehended, within arms, within the area of him.
I'm sorry. You said that
When they found Mr. Bush, they said within the area of his reach, they found a vial containing crack cocaine too.
Okay, and that was Officer Skidmore and Officer Douglas, correct?
Yes.
Do you know if anything else was located in apprehending the
Yes,
defendant?
a dog was also brought into the case to backtrack, as well as the statement from the security guard that I mentioned who saw him run through the gate, who also happened to say, hey, he did something over there by the shirt. And then so the dog also tracked back to the shirt to find the gun there too.
So there was marijuana on his person.
Yes.
A vial that contained crack cocaine around where he was apprehended, but then there was a firearm that was located where the security guard, the witness, said that he went over to while you guys were pursuing.
Yeah, well, he was fleeing from me towards where he was eventually caught.
Your Honor, can I have a moment?
You sure can.
Mr. Dagrin, do you know if Mr. Bush has ever read his Miranda rights when he was on the scene?
No, I don't know.
Your Honor, I have no further questions.
Okay. Mr. Franklin.
Okay. And it's Officer Dagrin, correct?
Yes, sir.
You said yes, sir?
Yes, sir.
All right, thank you. Okay, officer. So I heard that you said that you had been on beat patrol for about 2 years. How long have you been an officer?
From 7 up to now, 7.
7 years. Okay. Okay. And during the 7-year period, has all of that been with the city of Atlanta?
Yes.
And has it all been as some version of a patrol officer or a beat officer?
Yes.
Okay. Okay, so I imagine that in 7 years as a patrol officer, you've had occasion to write a bunch of reports, right?
Mm-hmm.
I'm sorry.
Yes.
And in writing those reports, you've learned what kind of information is important to include in those reports, right?
Yes, sir.
Okay. And you learn why it's important to include certain information in the report, right?
Well, it's pretty much the report, you just got to pretty much paint a picture of what you saw. So the person who wasn't there can actually visualize what they saw. The most important information is what we have to put in there.
Okay. And it's also important because you realize that the nature of your arrest, of the arrest that you effectuate, may cause you to end up on the stand like you are today, right?
Yes.
And it's to help you recall exactly what happened because you do a lot of arrests or you do a lot of patrolling, right?
Yes.
So you won't necessarily remember a random arrest from, say, a year ago.
That well, I don't believe that's true, sir, because certain things happen and they stick in your mind. And if you deal with someone enough times, you tend to remember something that was stressful in that moment, and the adrenaline was pumping.
Okay. So you write the report just purely to capture your memory from that day.
From that time, from that day, that experience.
Okay. Now, you made mention, I believe, during your direct testimony that you recognize Mr. Bush from prior interactions, yeah?
Yes.
And you wanted to talk to him because his name had come up in some other information that you had received from the streets.
Yes.
And so when you saw Mr. Bush, you wanted to stop.
I wanted to talk to him.
You wanted to talk to him. Were you going to talk to him while he was walking?
Yeah, general citizen contact. That's why I turned on the camera.
So a general citizen contact, a person is free to flee, right?
He's free to walk away.
He's free to flee, right?
Walk away.
He's not free to flee?
He can leave. He can walk away from me.
My question is he free to flee?
Yes, he can flee.
Okay.
If that's what you want to say.
I want you to say what's the law is or your understanding of the law.
You know what? That's actually not his job to say what the law is.
His understanding of the law is really relevant right now. And it'll be really relevant when I get to making my argument.
Okay. He doesn't decide the law, but you're free to ask him, and you guys just need to not argue over flee versus walk away. It's not real productive.
So it's a encounter that he's free to leave, in your words, right?
Mm-hmm.
So you need to make sure when you're answering,
yes,
it's a yes, or you answer any words you want, but if you say, our poor court reporter doesn't know what to write down.
Yes.
And I'm going to add this as well. I took my mask off because I know that I can't talk well with my mask on. If you're going to keep your mask on, and I don't know, social distancing and such, just speak up a little bit because it's muffling a bit.
Yes, sir.
Okay. You made mention that one of the things in your direct testimony, you weren't sure. You don't recall there being any cars in the street on Peachtree Street.
No.
Okay. Yeah.
No, that wasn't what you testified, or no?
No, I don't recall because
you don't recall.
Yeah, because I was focused on what I was doing.
You were focused on what you were doing, so you don't recall.
But that street is busy, so there's cars always coming down that street.
Okay, but you don't recall there being cars that
recall.
day at that point in time, right?
No.
And this is the far end of Peachtree Street.
This is the intersection of Peachtree Street and Trinity.
So if we're driving down Peachtree Street,
I'm
cross over Trinity.
I'm going south.
Right. So we're going south. We're gonna run into the city jail, right?
Yes.
And then after we pass the city jail, it kind of turns and merges into Memorial Drive, right?
Yes, but that's not how far we went.
I know. I'm familiar with the area too.
Okay.
What time of day was it? You may have already said this, but was it daytime?
It was
nighttime?
daytime, clear.
And by daytime, you mean 6 o'clock in the evening, right?
I can't recall the exact time, sir.
If you were to take a look at your report, would you be able to remember?
Based on the report, yes.
May I approach, Your Honor?
Sure. Do you have a copy you can leave with him so you don't have to go back and forth, or you just?
I only have the one copy.
Okay.
I can hold up to the. You have extra? Reading this one thing, I can do it really awkwardly in front of the class.
That's fine. I'm just trying to minimize the number of times you and he have to go back and forth.
$6 o'clock.
6 o'clock.
AM or PM?
That's gonna be PM.
Okay.
And this is January, right?
Yes, sir.
Okay. So it's January at 6 p.m. Okay. While you have your report up there, you make no mention of cars being in the street, right?
Yes, it says causing vehicles to brake suddenly and avoid hitting him attempting to flee.
Okay. So you made mention of several, you said vehicles, right?
Darting
Yes.
into traffic. Then attempting. Causing vehicles.
Okay. If you were to see a copy, if you were to see, you had your body camera on that day,
Mhm.
correct? You made mention of your body
Yes.
camera. You were able to see your body cam that day. Let me ask it this way. There were not
While
multiple.
you're rephrasing this, I'm curious. You had said you turned your body cam on when you got out to say hello to Mr.
Yes.
Bush. Then you pop back in your car. Is it running
It's
while you're
still
driving?
running. It's still running.
Okay, so you're, in theory, your body cam could, depending on how it's pointing, could show what you see ahead of you as you drive.
Yes.
Maybe that's where
If
you're
the
going.
steering
I was
wheel doesn't-
rephrasing
if
because
the
the way I was
steering wheel
about to
doesn't
ask
get
it.
in the way or anything like that.
Yeah, I was rephrasing because the way I was about to ask it would have elicited an objection. At the point in time that Mr. Bush ran into the street, there were not multiple cars between Trinity Avenue and where your car was positioned on Peachtree Street.
I don't recall that, sir.
Okay. If I was able to show you a copy of your body cam, would it refresh your recollection?
Whatever the camera caught, yes, you can.
Okay.
While you're getting that set up, Mr. Bridges has joined the Zoom call. So when we're done with this, we will get Mr. Reed out and at least have a conversation with Mr. Bridges and your grandson, nephew.
Thank you, Your Honor.
Okay. Ms. Hall informed me that the video I was going to attempt to play, if I played it through the actual courtroom system, it wouldn't show up on the Zoom.
Cause the courtroom to blow up. Yes, they have not figured out that part yet.
Okay.
So, Your Honor, what he advised me to do was to log into Zoom and just share the screen.
Okay.
I'll just do that for.
Sure.
Yeah.
And you all can, I mean, if it's not controverted, I'm happy for you to stipulate if you've seen the video as well. If it's easy to show it, you're welcome to show it. But if there's not a fight over there were no cars right there when he ran into the street, here it is.
Okay.
Great.
Okay. And are we stipulating that this is the video or do I need to lay the foundation?
Oh, no, I know what you did.
Okay.
Video.
Okay. So let's play. And at that point in time, you can pause.
You said first
Yeah,
pause?
you can pause.
Oh, I'm sorry. Sorry.
Okay, let's pause because I need to get oriented. I think I know what I just saw there, but why don't you have him narrate?
Okay. And Cassie, we can move it back about 7 seconds to where we see the red. Okay, Officer Dagger.
Yes.
So when Mr. McKenzie first runs into the street,
That's Mr. Bush, not Mr.
I'm sorry,
McKenzie.
you mentioned Mr. McKenzie. When Mr. Bush first runs into the street, there are no cars traveling north on Peachtree Street, correct?
As of right now, no, but there's one car traveling south.
Okay, I hear you. And the car that's traveling south is pulling over to the side of the street, right?
Yes,
Okay, and that car eventually stops on the side of the street, right?
yes,
Okay.
because Mr. Bush cut
that
out.
was a yes or no question. I appreciate it.
He can explain his answer. You can, if you want to object to
offering
it, he's
narrative.
allowed to explain his
I asked
answer.
a yes or no question. He's offering a narrative that is not responsive to this point. If the state wishes to clarify, then that's something I believe that would be addressed or recross.
Okay, so we're clear. A lot of your leading questions, which are appropriate on cross, are yes or no answers, and witnesses are always allowed to explain their answers. So I'm going to let him explain it. I think I've heard it. His observation was that that car did pull over because he perceived that it was getting out of the way of this guy running down the street. That's his perception.
Okay, we would object to speculation.
Okay, noted.
Okay. You never spoke to the driver of this red car, right?
No, because I was busy trying to get Mr.
Right,
Bush.
so you don't know what the officer.
Don't interrupt him. Let him finish his answer.
I was busy chasing after Mr. Bush.
Okay, and because you were so busy, you never had an opportunity to figure out why that person pulled to the side of the street, right?
That wasn't the most important thing. Mr. Bush was.
So you did not speak to that person.
No,
So you're not able to say what that person pulled over for.
I don't even know if he pulled over. He doesn't look like he's pulling over to me.
Okay. Can you rewind the video, please? First play, I'll take you to pause. Okay, pause. Pause, please. Thank you. You've observed the red car in this portion of the video?
I seen the car pass.
Which
by.
lane is he in?
He is, I'm in the lane by the sidewalk. He's in the inside lane,
He's on the inside lane and you're in the lane by the sidewalk.
outside lane.
Okay. He then or the person driving the car then pulls into the sidewalk lane, correct?
After going around me, yes.
Okay.
Pulls into the what?
He pulls onto my
To the
right.
sidewalk, the lane next to the sidewalk. Okay. The car could not have continued in the lane that you were in because you were in that lane, right?
Yes.
So the car then went
Goes
around
around
you.
me.
Okay.
Does body cam, it does have audio.
Yes, it kicks in after 2 minutes.
Okay. Why would it not kick in right away?
That's the
just
buffer
the
they
way it
have. I
works.
don't know what that's what they have.
That won't lead to any issues.
Yeah, I think it records generally, and unless the officer alerts it to
Yeah.
actually keep us going, it's like a continuous thing, and it won't dedicate volume to things that it may not need to keep. Okay. Now, additionally, you made mention during your direct testimony that, of course, a gun was found, right?
Mhm.
Yes.
And
Yes, sorry. Yes.
sorry.
Yes.
And that you said it was found by a shirt in your report. Is that the jacket that you're referencing?
It just said a shirt, that's all.
Okay. The gun itself was not found with the shirt. It was found with a pair of pants, right?
I wasn't actually there. This is what was Mr. Skidmore and Mr. Douglas wrote their part of the report.
To your understanding,
Yes,
the gun was found underneath a pair of pants.
clothing, clothing.
Your report makes mention of a shirt or makes mention of a jacket that Mr. Bush was supposedly wearing, correct?
Yes, he was wearing a jacket too.
Okay. Your report makes mention of a pair of pants.
Objection, Your Honor. Asked and answered several times.
It's not
Well, it's sort of been asked, it hasn't been answered, so you can
Okay.
keep exploring it. I'm confused about the
Okay.
clothing.
There's a pair of pants that's found elsewhere, correct?
Well, Mr. Skidmore and Mr. Douglas.
I'm sorry, per your understand, per what you put in your report and your understanding.
Per whatever's on the report, that's where it was found.
Okay, so the gun was found underneath a pair of pants. Page 4, line 4, end of that sentence.
Page 4.
Yes, sir.
I have one page. Read that again.
You all have the same
I don't
version
know
of
if we
it.
have the
Sometimes it
same.
prints out differently.
Yeah, because I don't, because
The
what do you
the
have?
one that I'm looking at appears to be the one that I recall handing to him.
Sure.
At the top of it, the top right-hand corner, it says page 4.
Oh, back, see?
It's all right.
That's
Okay. So the jacket was found, to your understanding, somewhere near the base of this bridge thing, correct?
based on what was told to me.
Correct. And based on what was told to you, the pants were about 20 yards away from this jacket, correct? I believe that's the second line.
Based on the report, yes.
And it was underneath a pair of pants.
Yes,
Okay. And Mr. Bush wasn't wearing a jacket that you had seen him wearing earlier, correct?
he was wearing a black jacket and he wasn't wearing that jacket.
He was wearing a different jacket?
No, he was wearing a black jacket when initially he
Correct.
didn't have it on after that.
At the point in time you encountered him for the search,
On
he
the
didn't have
other
it on
side,
anymore.
yeah.
Okay.
So we can see what he's wearing on the screen right now. And so what you're saying is the top outer layer was
Yeah,
gone
he shielded that.
when you saw him in custody.
Yes,
Okay. When you saw him in custody, he was still wearing pants, correct?
yes, black pants.
Okay. And your testimony on direct, as I recall, you personally did not read, nor were you present for the reading of any Miranda rights, correct?
No, sir.
That's it for now, Your Honor.
Okay. Do you have any redirect, Ms. Hall?
Maybe a few, Your Honor. I just wanted to clarify with Officer Dagner, when you mentioned multiple vehicles, when you were pursuing the defendant, were you only referring to the vehicles or vehicle that was on P Street or throughout your entire?
Throughout the whole time I'm following him.
So there was other times where he was in the roadway other than on Peachtree Street?
Yes, because I too had to stop to avoid other things too. So
And you said you searched him when everything came to an end and he was apprehended?
when I met him on Peachtree Street, when they brought him from the woods behind the storage place, there we also searched him too.
And when you searched him, was that incident to arrest?
Yes, and the marijuana was found on him there.
And the person that you searched, do you see him in the courtroom today?
Yeah, Mr. Bush.
Can you identify where he's sitting in the article of clothing that he's wearing?
A white or gray long sleeve, blue shirt over it with the black face mask, small dreads on top.
Thank you. And this is the person that fled from you in the street that day.
Yes, that's him.
Your Honor, can the record reflect that Officer Dargan has identified the defendant?
He has.
And Officer Dargan, the gun, where I know you weren't involved in that tracking of where the gun was located, but you did mention that a witness pointed you all to that direction.
Yes,
that
the
direction.
security guard who was securing the construction area pointed at us. I said he hid something underneath the clothing over there.
It is hearsay. In this context, it's admissible.
The security guard was actually helping us at the time when he jumped over. He was the one who pointed, said he went through the gate and he did something over there by the clothing, whatever it was, and then he continued to go. So someone always had eyes on him, was helping us the whole time.
Okay. And the direction that the security officer was pointing you all to, was it a consistent direction the same way?
It was southbound on the railroad tracks.
And could you see down on the railroad tracks?
Yes, you can see down the railroad
There-
tracks, standing from where I'm standing.
I'm sorry, I didn't mean to interrupt. When you look down, could you see any other things that were on the railroad tracks that were left, like clothes, beer cans, anything other than what you guys discovered at the end? This pursuit?
Where he ran, I couldn't see underneath. I could just see when he got out in vision, so I could keep eyes on him running. We were doing good, so several people had eyes on him, depending on which side they were standing on. I happened to be standing where the security guard was, and I could see him once he broke from under the bridge.
Okay. And the last thing, Officer Dagger, I'm gonna rewind this body cam back to the very beginning. Can you see that from your screen?
Yes,
Where is the defendant standing from where you can see?
on the sidewalk.
And we don't have audio for this portion of the body cam. So I see there's two people looking at you. At what point do you say something to the defendant? I'm gonna press play and then I'm gonna let you narrate and then I'm gonna stop. It's gonna just be the first 10 seconds.
Yeah, I've already said, hey, can I talk to you? And he says, because it was a tense moment. I remember, I pretty much can recall almost what he said. I said, hey, Mr. Bush, I gotta talk to you, and something like that. And he goes, Dagrin, why you want to talk to me for? And then he just backpedals and just runs off into the street.
Okay. And so I'm gonna press play again. And once he runs in the street, I know there is a vehicle there that could have been going around your parked vehicle or could have been avoiding the defendant. But I want you to describe what you saw when you were present, pursuing the defendant.
Runs off. He's like, why you following me? Car pulls over. No, it doesn't pull over, but he changed. See, he runs in front of the car because the car's going straight.
Right, I was trying to stop it at that point.
Yeah, the car's going straight. It's a green light and the car's going straight.
So at that moment, do you still have eyes on the defendant at this
Yes,
moment?
I'm looking right down the street.
And does he cross in front of that vehicle way before the vehicle approaches the light?
Yes, he actually crosses in front of it, the vehicle, and then goes right up Trinity.
No further questions, Your Honor.
Looking at that video and from your recollection, officer, that car stopped, right? It was able to yield.
What happened?
The car was able to stop.
It was able to stop as he crossed in front of him.
The car stopped.
Yes, it attempted to stop.
It attempted to stop. Was the car unable to stop?
It eventually stopped. That's why he didn't get hit.
So Mr. Bush did not get hit because the car was able to stop.
Yes, while it had the green light.
Thank you. Other question. You made mention of this conversation with a construction worker.
No.
Of the person working.
Security guard in a
I'm
construction
sorry.
site.
And you gave a recitation of what he told you at that point in time, right?
Yes, sir.
In your report on the first page, the 10th line, you referenced the conversation with that security guard, correct?
Your question was it in the report or he just talked about it while testifying?
Let me rephrase that. In your recorded recollection, your report, you make no mention of the security guard saying anything about Mr. Bush discarding any clothing, correct? He just told you which way he was running.
Yes, but you could also listen to the body cam too if you wanted to.
You didn't put it in your report, right?
I didn't put that in the
And we
report.
talked about how important it is.
Yes,
being
but
an
I
experienced
put,
officer.
Don't interrupt Mr. Franklin until he's done. He'll
being
have
an-
his question, and I promise you can say more than yes or no.
And being an experienced officer, we talked about the fact that you, 7 years on the job, know the importance of putting important things in your report, right?
yes, sir.
Nothing further.
Anything else, Ms. Hall?
Nothing further from the state, Your Honor.
Officer Dagman, thank you for your time. Appreciate you being here. You can leave the report right there. Someone will get that. Whoever it belongs to will collect it. Is Officer Dagman free to go?
He is, Your Honor.
All right. Thank you, sir. Appreciate your time. You're free to stay as well. You just don't need to be at the stand anymore. Mr. Franklin, that is it for the state's witnesses today. I'm curious, I'm gonna give you a chance to make some argument now. As I had reviewed your motion, it seems like the basis for your challenge to what ultimately was the seizure of your client and then search and seizure of some of the items flows from what we've heard about, which is another way of saying, I don't know, that hearing from Skidmore or Douglas about how they ultimately were able to catch up to your client would change the analysis that I need to perform on your argument. That said, I want to make sure if you think hearing from either of them would strengthen your case, that we give you that opportunity. You also are free, as you said, I'm done waiting. This was the state's chance to get folks in here. I don't know in terms of the suppress, the stop, and the seizure that we need anyone else. But I don't mean to define your argument for you.
No, you essentially made my argument. The question about the statements and whether we're going to reset that for another day, that's a totally different consideration.
Okay.
From my point of view, I don't believe that there is a need for any other witness, because whether Officer Dagren was lawful
that seems to be the key from the analysis I think I need to make from your motion.
Correct.
It was Dagren and Bush, not Skidmore and Bush or Douglas and Bush,
right,
that decides how this plays out.
Yes, sir.
Okay. Ms. Hall, do you agree, or are you asking to keep the record open in the motion to suppress what was seized?
No, Your Honor, I agree.
Okay. Then the evidence is closed in that. Just to put a punctuation mark on the Jackson-Deno, one can do a Jackson-Deno at the time of trial. I don't think we need to defer it that long, but I have two concerns about it. One, that the nature of Officer Douglas's unavailability is one that is I think beyond his control, and I don't attribute to the state because it's FMLA. Two, I want to make sure that there's not another statement out there that you ought to think through whether you want to suppress, so that we don't have to have two hearings about suppressing statements. Because I thought I heard Ms. Hall say there is a statement that Mr. Bush gave once he was down at the precinct or headquarters or wherever he may have gone. And you seem to, Mr. Franklin, not to be aware of that. I may have misunderstood what you said, but your motion challenges the field encounter, what was said out in the field, and not what was said in the station house. And maybe that's because the station house interview in your mind was well done.
Yeah. My recollection is that, at least per the report, it referenced this field admission. And from what I was able to view on the body cam, the audio was pretty low. I couldn't hear everything, but the fact that he is alleged to have made an admission, certainly I'm going to challenge that. I don't recall seeing a video that looked like it was in a station house, but was a 12 or so videos on there. I could have just skipped over it thinking I had looked at it already. I trust Ms. Hall when she says that it was there. So
Okay.
I'm certainly not alleging any.
No, and I didn't hear you say that. It may well have been delivered to you, but it seems like we ought to connect that dot first to see if there's an additional statement that you want to challenge on the Jackson Deno side.
I certainly understand the court's interest in not doing the same kind of hearing twice. So I would defer to the court in that regard. I would still ask that the field investigation, given the circumstances that I made mention of, I'm not sure of the details of the FMLA, whether we missed it. He was not able to attend last time because of FMLA. It's just a continuation of the same FMLA.
I don't know what happened last time.
Yeah, his wife had a baby, he's been out for 90 days, then I don't want to just take advantage of the fact he was out on FMLA for the same reason. But if it was something different, I would still make the request, but I'm not gonna jump up and down and scream about it.
Okay, noted. Let's hear argument about the motion to suppress the evidence that was seized. And as I understand it, there would be three things the state would try to get in. Marijuana purportedly found on Mr. Bush, cocaine, suspected cocaine, found near Mr. Bush, and a gun found under some clothing that was found because a canine unit ended up there. But the evidence I've heard was that already a security guard was saying, hey, that guy did something with some clothes under the bridge. But it's those three items. It's gun, marijuana, and cocaine, all of which would be fruits of a poisonous tree if the initial encounter was problematic. And that seems to be what Mr. Franklin is challenging, is that initial encounter, which we got to hear a lot about. So given that, Mr. Franklin, why don't you tell me why you think I ought to exclude, it would be, I guess, all three. There's not an independent discovery because I want to hear from you.
Yeah. So to begin, if we look at the indictment, Mr. Bush is charged with pedestrian in the roadway based on OCGA 40-6-91 subsection B. That statute provides.
Can you say those numbers again?
40-6-91 subsection B.
91 Bravo.
Yes.
Okay.
That portion of the statute provides no pedestrian shall suddenly leave a curb or other place of safety and walk or run into the path of a vehicle which is so close that it is impractical for the driver to yield. So certainly if we begin to read the sentence, things don't look so great for Mr. Bush. He certainly left the sidewalk or curb suddenly or a place of safety. And he certainly did walk or run into the path, walk into a street. We've seen the video, and one thing I would like to do, Your Honor, we published the video. If we could reopen just to make sure that we actually admit that video.
Sure. Do you have a CD that I can end up keeping? You don't have to hand it to me now, but we'll make that State's Exhibit 1.
I have it on.
So if we call it States 1?
That's fine.
Okay, so it was stipulated to that this was a copy of the body cam video footage from Officer Dagrin. That both sides stipulated to that. I don't think there was a formal move to admit it, but it is admitted.
Thank you. We see in that video the initial retreat by Mr. Bush. We see him running into the street. We see that the vehicle, the one vehicle that's on Peachtree Street at around 6 p.m. This evening, on that evening. He's behind that vehicle. The car was in the inside lane, and before Mr. Bush is able to pass it, the car pulls over to the side. We can argue whether or not he pulled over to the side because Mr. Bush was getting ready to run in front of him. I think it's plausible that this person sees the officer get ready to hop into his car, sees this gentleman running, and like a regular person can kind of infer that a chase is about to occur. But whatever the reason I engaged in a really odd line of questioning about whether the car stopped towards the end of my questioning is because the statute does, an element is that it's impractical for the driver to yield. So theoretically, if I were to just walk in the street and a car is 50 yards away, and I just ran into the street and it didn't affect that car such that it had to brake, that would not be a violation of the pedestrian and the roadway statute. If a car is able to safely brake, safely get to a position of safety, the statute is not violated. And therefore, Officer Dagger's representation that this was a tier 1 encounter. We argued over the language, whether it was flee or leave, but he certainly was able to divorce himself of that encounter, Mr. Bush was, of his own free will. He did what Officer Dagger stated would be okay. And I would argue that he did so in a fashion that did not violate the statute. At that point in time, if the officer's failed seizure results in his stop, which the reason why he began to chase was not because of what might have happened on Trinity Street. It's not what might have happened in a parking lot. It's not what might have happened on Ted Turner as he crossed that street to get to the Peter Street Bridge. We didn't use that term, but that's where the bridge is located. Whether he later at that point in time possibly ran into the path of a vehicle, I would argue is irrelevant because he's already been illegally seized on Peachtree Street.
When was the seizure part? Because the car started to pursue him?
At the point in time that Mr. Officer Dagger began to pursue. Because he's certainly not free to, they called a bunch of officers. Wherever he was not free to go home and remain home.
So your argument is, part of your argument is that the seizure began when Officer Dagrin hopped in the squad car and began driving after your client.
Correct. It's
But if he had never been caught, if Mr. Bush had gotten away, how would he have been? Would he have escaped a seizure?
It would have been a failed seizure, and we'll probably be arguing the same thing as to whether or not an obstruction of law enforcement charge or whatever charge they came up with at that point in time would be. The success of the seizure, I mean, the fact that it was eventually successful, it just took some time. I'm not sure if that is the fulcrum of the determination.
You may be right. I'm remembering Hodari D, and if you go far enough back, and it may be that person gets away initially, but throws something down during a wrongful pursuit. And can that be used again? I'll have to work through that, but okay.
But as the officer initially represented, and as I cited in my motion, he said that Mr. Bush was free to leave. I cited case law, a Woman v. State, that says a person has a right to flee. And if the officer only engaged in a chase because he had a misunderstanding of what the law actually provided, that's why we engaged in that back and forth.
Okay.
Because a misunderstanding would further my position that this was an unlawful, initially failed seizure, but initially he was caught and effectuated.
Do you know what Mr. Bush was arrested for? I understand what he's indicted for, but of course, Officer Dagrin doesn't control what the state charges ultimately.
At the point in time that he was placed in cuffs, the only thing he could have been arrested for was the pedestrian and roadway, because the search had not yet been effectuated. They could not have found the marijuana until part of this timeline, we understand, until he was searched. And there has not been a connection made.
Well, but I guess I didn't ask the question well. At some point, he has to have been issued citation, whatever, you know, he's arrested for something and the police fill out paperwork. Do you know, it's knowable, we'll figure it out, because
as best as I guess, I think they just wrote out all the tickets or the citations at the same time.
Right.
But certainly they were in knowledge, possession of knowledge of one thing before the other. They didn't find the gun.
Oh, no, that's not my point. I agree with you that the basis for physically grabbing Mr. Bush in the end wasn't the gun, wasn't the cocaine, certainly wasn't the marijuana. But I'm curious if it was 91B, what's in the indictment, or if in fact there's a ticket for jaywalking. Is there a citation for I don't know the traffic code real well. I know you're not supposed to speed or run red lights, but you know, if he was arrested for something other than what's in the indictment, then your analysis may be slightly misplaced, if that makes sense. I'm not critiquing your analysis. It's just, if the police didn't use 91B, they used, and I'm making this up, 91A, which is, it actually is against the law to run down the middle of the street, whether there are cars or no cars. That is a different basis for running after him.
The ticket references pedestrian darting into traffic, possession of crack cocaine, possession of marijuana, possession of firearm, possession of fire by convicted felon and in commission of felony, and obstruction of law enforcement officer.
Okay.
And
does it give the same code cite? The very first one is, that's the money one. Is it 91B, or they don't give a code citation?
It's 91B.
I'm sorry.
It's 91B.
It's 91B.
Okay, all right, so that narrows our universe. It's not that the DA's office decided to charge it differently than how he was arrested, which often happens. Okay.
Correct. And to the extent there is this charge, I don't recall if it's part of the indictment, the obstruction of law enforcement officer is in the ticket. But again, we would, just to address that as part of the initial arrest, we argue that the officer wasn't lawfully enforcing his duties because he was taking a person into custody who had a right to flee.
Right, as I understand it, and I'll need to refresh on it, the obstruction would be valid if there was a 91B violation. You need to stop. You darted into traffic in a way you shouldn't have. And your failure to stop then, now that a crime has occurred, would support the obstruction charge. So if I find that there was a 91B violation, then the obstruction flows naturally from that. But to your point, it can't just be that someone runs away from an officer. That's the whole point of that change in the constitutional law, that leaving a police citizen encounter cannot be the basis for obstruction, or you could never leave.
Correct.
Okay. All right, anything else before I have Ms. Hall respond?
No, sir.
Okay. Ms. Hall.
Yes, Your Honor, thank you.
Welcome.
Your Honor, the state asked that you deny the defendant's motion based on the testimony that you heard from Officer Dagrin today, that his initial encounter with the defendant was a tier 1 stop. He was just a citizen encounter. The defendant had absolute right to leave that encounter in whichever way he chose, except for breaking a law, which he did when he ran into the street. Our indictment, as y'all were just discussing, did also charge him with obstruction once he fled and did not stop after running into the street. I did want to mention the point that defense counsel was making about that red vehicle, that one particular vehicle that tried to avoid or may have tried to avoid the defendant. There was a very quick encounter that we saw, maybe 7 or 8 seconds, but we did see that at some point that car did try to come to a stop. We don't know at what circumstance. We don't know who was inside of that car, what happened after, because we pursued the defendant. So I wouldn't say that they did that in a safe way, because we don't know the circumstances of how that was done. But the officer also testified that that wasn't the only encounter that the defendant had with other vehicles in the middle of the road where they tried to avoid him, and even such that the officer had to avoid certain encounters. Once they did, as you heard, once they did reach the defendant or apprehended the defendant, search incident to arrest, he had marijuana on him. There was one particular witness that pointed out the gun not the gun, but the location that the defendant ran over to and the cocaine that was found close to where the defendant was apprehended. We contend that all would have been found had Mr. Bush had not discarded that stuff when he was apprehended. I can't speak on the statements, but we do, as far as the search and seizure of the drugs and the gun and the seizure of Mr. Bush, we do ask that you deny the motion, because it was a lawful stop once he ran into the street. And another obstruction charge. And once he didn't stop and he continued to run after multiple officers told him to stop running or to stop fleeing from officers. So for those reasons, Your Honor, we ask that you deny the defendant's motion.
So part of Mr. Franklin's argument is it doesn't, hold on one second, let's pause the record. Mr. Lyles, we're almost done here and then we'll bring the gentleman out who needs your services. Sorry to keep you waiting, but we're almost ready for that.
Yeah, no more.
That's okay, you're free. I know you need to be in lots of places. Sorry, we'll get back on the record. Part of Mr. Franklin's argument is there may well have been illegal darting later on in the chase. It's what you're describing, onto Trinity, and it's what Officer Dagrin described, that there were points during his pursuit of Mr. Bush where unquestionably cars were having to swerve, avoid, et cetera, that might more clearly fit 91B. But Mr. Franklin has argued once Officer Dagrin got in his car and started driving after Mr. Bush, he had either effectively seized him or begun the seizure. So I shouldn't consider anything Mr. Bush did after that as support for a 91B charge that would justify his ultimate arrest. Do you agree with that? And if you don't, tell me why you don't agree with that. If my question made sense, I'll rephrase it.
I want to make sure I understand it. So you're saying that counsel is mentioning, or his argument is that the officer Dagrin seized the defendant once he started to pursue him, rather than just trying to arrest him from darting in the street.
I want to be clear for the record and for Mr. Franklin. I'm not putting words in his mouth, but I pressed him a bit on, well, maybe there is a question mark about whether, I'm going to use shorthand, the word darting for a violation of 91B. Was 91B violated the way Mr. Bush and the red car interacted? Maybe there's a question about that. Well, does that really matter if Officer Dagrin has testified, well, once he got on a Trinity, cars were having to swerve and pull and this and that, and that's more or less Dagrin's testimony. Mr. Franklin is saying you should not consider that because by that point, Dagrin was in a squad car. I saw the blue lights were on. So he is pursuing Mr. Bush. Mr. Bush is no longer free to leave. And so whether we say the seizure has started or whatever you want to call it, that by then the law enforcement has already violated his Fourth Amendment rights. Does that, you don't need to agree with it. That's
right. It makes sense. Your question makes sense, Your Honor.
Okay.
I disagree with defense counsel on that analysis. I feel is when, we can interpret that statute as how we want to, as far as the sudden stopping and the pedestrian in the vehicle. But when the defendant went into the roadway, and there was a vehicle there that we clearly saw try to avoid him, in which way we cannot figure out. I believe, or the state believes, that at that point, the defendant had broken the law and the Officer Dagrin had all right to seize him, to arrest him.
Okay, I hear you on that. I'm going to try one more time with the question because I have not been asking it well. Let's say for a moment that I find because Mr. Bush actually went behind the red car. So initially the red car didn't need to do anything because Mr. Bush went behind it. Now it gets muddier beyond that because now he's running down the middle of the street and there's no other reason it appears why the red car is going to be going over here. Although I heard Mr. Franklin's argument that it needed to get around Dagrin's car, but it appears to be a reaction to this guy running down the street right behind the red car. I'm going to get out of the way. But assume for a minute that that's not a 91B violation. Officer Dagrin drives after Mr. Bush. Was it improper for him to do that? And did that driving after him elevate this to a tier 2 encounter in a way that violated Mr. Bush's rights? Because if it didn't, if the officer was free to pursue, then the later darting that occurred is something that I should analyze as being a basis for the ultimate arrest. Because everything, I think we agree, everything has to flow from the darting. And if the police started doing something they shouldn't before the subsequent darting, Mr. Franklin's argument may carry the day. But if Dagren's driving after Mr. Bush was acceptable police conduct that did not constitute, you may want to think about it. I'm not trying to put you on the spot. I haven't worked through this issue before. And you may not have either.
I haven't, and I think we could have gotten better clarity if I had asked the officer more questions about this particular part. But I do feel like the officer wasn't doing anything wrong by pursuing the defendant once he did initially dart out, and that you should consider the continuation of the darting and the obstructing throughout the fleet.
Okay. Thank you.
You're welcome.
You can have the final word. It's your motion.
As it pertains to any, I don't think that Officer Gabbard came in and intentionally misled the court. But I do think that when you do a lot of arrests and stops and stuff, that you don't remember everything. I wouldn't expect anyone to. I had clients who I've re-encountered and, hey, Mr. Franklin, I'm like, yeah, who are you? So I totally get that you don't remember everything to that extent. The officers' representations of these later dartings, I believe that they should not be given a meaningful weight in terms of credibility by the fact that before we engaged in cross-examination, he made mention that this occurred during the afternoon and that it's Peachtree Street and it's a bunch of cars. That's how he remembered it. We played the video. We see one car for a while, like you can see down the street and see that somewhere after the light on Trinity, there's some headlights, I believe, but there certainly aren't a number of cars. Now, after we got into cross-examination, we get back to redirect, then it kind of gets clarified. But I'm talking about the whole chase. That's not what was said, sir. And so typically, unless we have a smoking gun that says, oh, this officer is wrong or actively lying, there is a level of credit given to the fact that an officer who's sworn under his badge and in court further sworn to tell the truth is not going to purposely present inaccurate information through no intent. I think that we already know that he has done that in regards to his recollection as to how this chase going, because it's a chase. Like, you're not trying to document, I made a 37-degree turn and swerved through this. And just because he is in a car and almost runs into someone, in this set of circumstances, a car is more clumsy than a person on foot. And it's not a irrebuttable presumption that just because the officer almost ran into somebody, that Mr. Bush did. So I would ask that, well, unless the evidence is closed, we have no indication that these other dartings actually occurred to
Well,
believe.
let me ask, if you remember, and I'll get to view it, does the body cam footage, it looks like the camera shows the steering wheel.
The car.
And so you can't really see.
Correct.
So if I were to watch more of the body cam footage, I'm not gonna see what Officer Dagren is seeing over the dashboard. Is that your recollection?
Until he gets out the car.
Okay, sure. But then he's explained he got out and was interacting with the security guard. The guy messed with some clothes over there, and then he also encounters his colleagues. But it's not going to show what Officer Dagren is seeing as he drives his car.
Correct.
Okay. All right. Anything else?
I'm sure when I walk out of here, there'll be something, but no, not right now.
Okay. Well, I want to thank everyone for their preparation. Officer Dagren, thank you again for coming in here. I will take this under advisement. It presents a couple interesting legal questions like these motions. and I'll get an order out. I am going to defer the Jackson Deno motion because I want to make sure that we're covering the whole waterfront. So Ms. Hall, if you and Mr. Franklin could please confer about a statement made at the station house or wherever it was, so that Mr. Franklin can amend if he wants to add that as well. And then if you could let Ms. Nelson know when Officer Douglas is going to be done with his FMLA. We'll need him for at least the Jackson Deno as it stands. We may need someone else if there is an amendment to the motion to seek to suppress whatever was said at the station house.
Okay.
Does that make sense?
Yes, Your Honor.
So we'll circle back on that. But because there may be a reason to dig deeper into statements, and that is the defense that wasn't ready for that, I'm going to balance it and say, let's revisit the statements. That doesn't need to delay things. I will rule on this. We can move this to a final plea, but we'll also try to get the right folks in here to talk about the statements, which should be a less involved hearing. Anything else, Ms. Hall, for the state?
Nothing else from the state, Your Honor.
Mr. Franklin? Okay. Mr. Bush, you sat patiently while you heard the testimony. Mr. Franklin, I actually never asked you if you wanted to present any evidence during the suppression hearing. I assume you would have jumped up and down if you had wanted to, but there was no witness you wanted to call.
No, sir.
Okay. Well, Mr. Bush, you got to hear what was said. I'm going to enter an order on that motion. You and Mr. Franklin will talk about what's next for you, okay? All right. Appreciate it. If we could bring Mr. Ortega Ramirez out next for about 30 seconds. Then we'll do Mr. Reed. Thank you. Do you know what the thumb drive is as opposed to the disc? I'll ask Ms. Hall.
Here's what she played off her computer.
Okay.
So the disc that she originally gave me had several videos on it. So I had also copied just that video onto my flash drive, just to make sure we didn't give the entire set of discovery evidence.
I can stand.
Mr. Lyres, I'm not going to swear you in. This is not on the record. I just want to explain to Mr. Ortega where we are. First of all, good morning. Ms. Patel, I think you got word that management at the jail informed me that Mr. Ortega wasn't moved to where you asked to, but was now with more Spanish-speaking individuals.
Yes, Your Honor.
You've confirmed that?
I have not confirmed that with my client.
Let's do that.
how it's moving.
Your Honor was able to confirm that he is being housed with other Spanish-speaking inmates.
And that's a better situation?
Yes, it's more calm.
Yes, Your Honor. He's confirmed that it's better. It's more calm. for
More
him.
calm. Okay, thank you. Good. Glad to hear that. Mr. Ortega, we talked about two things in your case today. We need to figure out, if you have a trial, how many translators need to be in court? You will need a translator for the entire trial. But we'll also need translators for some of the witnesses who speak Spanish. We also talked about some interviews that were done in Spanish, and whether the prosecution is going to get those translated into English for a jury. Once we figure all that out, we should be ready for a trial of your case. Okay? Anything you want to talk to him about?
Just briefly, Your Honor.
Sure. All right, we will see you soon. See you soon. All right, we're gonna bring Mr. Reed out next. Mr. Bridges. There he is.
Good morning, Your Honor.
Thank you for your patience.
Not a problem.
Huh? Yeah. Okay. No, don't look forward. What you mean?
Oh, okay, okay, because they everywhere, okay.
Great. You did receive the info though? Great. Okay. There you go. Thank you, sir. Okay. Good morning, Mr. Reed. How are you doing? I can understand, just all right. Well, hey, we have your lawyer, Mr. Bridges, on the call there. You can see the gentleman with the distinguished chambers there that he just waved at you. That's Mr. Bridges. I was just confirming on my screen here. He is the attorney of record for both your cases. I have two cases with you. One charges you with some burglaries, and you had some co-defendants on that, Mr. Anderson and Mr. Chavies. They've resolved their case. And then you have an older case that charges you with some drug possession. And that joined us because of the newer case. We're gonna move the microphone so that your lawyer can hear you. Thank you, Mr. Forte. So we brought you here, Mr. Reed, just to make sure we had a lawyer for you. You had a lawyer initially, but there was a conflict because of co-defendants, and Mr. Bridges has been appointed to handle your matters going forward. Ms. Hall is the prosecutor. You can see her seated over there. And we just need to figure out what the right next step is in these cases so that we make sure they're moving along. Ms. Nelson, had Mr. Reed already been arraigned in the 19 SC case, or do we need to work through that? No, it doesn't look like he's been arraigned.
I don't think he'd been arraigned.
Pardon me?
I do not believe he had been arraigned on that case.
No, I don't show anything along those lines. It was a judicial hold, and then Mr. Reed was arrested, and then we got Mr. Bridges involved. So we're going to start at the beginning. Mr. Bridges, we need to work through whether Mr. Reed wants to be formally arraigned or if you're going to waive arraignment on his behalf. He has two family members here, his aunt and his grandmother. They asked when I called the calendar before we got you on the call about bond. I explained to them that you would be the person to file a bond motion on behalf of Mr. Reed, and as soon as you did that, the state would be on notice that we would have a bond hearing. We can do that virtually. You can waive Mr. Reed's appearance, and then we can do it even sooner. But I'll let you work on schedules with Ms. Nelson so that if that's something you want to pursue, that's something that we can do in the near term. But let's start with arraignment. Do you need to meet with Mr. Reed to sort out whether he wants to be formally arraigned, or do you know whether he wants to waive arraignment?
Your Honor, we can waive arraignment, but just for the courts to know, Mr. Reed has 7 other cases that are coming down the pipeline.
Oh,
all of them
okay.
are burglaries, and one of them is a domestic violence case. So I'm assuming at some point those cases will catch up with this court. So
they will come here.
Yes,
So
Your Honor.
have you been talking with the DA's office, and that's how you know it, or you know that from Mr. Reed and his family?
I know that because when they appointed me to these 2 cases, they gave me 7 other cases.
All right. So does that mean you get to skip 7 other appointments, or this one will be a handful?
This is going to be a handful, Your Honor, but no, they don't allow me to skip anything.
Okay. Well, I appreciate you staying involved with all those. So do you know if those other burglaries have CP numbers, or are these fingerprint matches, or what's the status of them?
Your Honor, at this time, only information I have is what the Georgia Public Defender Standard Council has given me and appointing me to these cases.
Mhm.
I have submitted for discovery on all the cases, including the 2 that are before you. But I was just recently appointed to the cases. So, and I understand with the pandemic that the state is probably behind getting that discovery to me, but I have submitted for requested discovery on those cases.
Okay.
They're CP cases right now, Judge.
Okay. So I guess we need to do a couple things. We can handle the waiver of arraignment, and there's some paperwork that you just need to e-file, Mr. Bridges, but that's not hard to do. But then we don't want to get too far out ahead of those other 7. I don't know that it makes much sense to talk about bond on either of these 2 cases with all those other things trundling down the pipeline. I know with the new district attorney in place, they are taking a careful look at CP cases to figure out, do they move forward or not? And they are in the midst of doing that. So maybe what we ought to do is put this case on a status calendar, these 2 cases, on a status calendar a few weeks out, to give Ms. Hall a chance to make some inquiries with the, I don't know what it's going to be called, there's no more complaint room, but the charging unit, to see if they can shed any light on a time frame for these other cases. Because it doesn't benefit anyone to piecemeal it and drag Mr. Bridges and Mr. Reed back into court 1, 2, 3. We ought to try to get all these bundled together. I suspect that's how they'll get resolved as well, is a global resolution. Does that work for you, Mr. Bridges? If we basically break for a few weeks, let Ms. Hall make some inquiries as to what's happening with the CP cases, and then she and you can talk, and it may be that the way that Mr. Reed wants to move forward would be to waive the grand jury and allow those to be accused. I don't know anything about them. They may be airtight cases. They may be factually very, very weak cases, and that would affect the decision you make, Mr. Bridges, but that would be a way to bring everything together sooner, depending on what you can learn from the state about those other cases.
Your Honor, what I'm doing right now, I'm sending my contact information to Ms. Hall so she can have it and we can discuss it further, but I have no problem with this matter going to status calendar. I've already explained to Mr. Reed there's a possible delay in this matter with the number of cases that we have, and that bond would, was something that we could look at later, but it's probably not probable right now.
Okay. All right. Mr. Reed, you've been listening to what we've been talking about, and they're all about you. It's your cases. Do you have any questions for me? Not about the facts of your case, but sort of the process that we just discussed?
Yes. Can I be put on like house arrest until everything? I don't want to keep sitting in jail.
So it's a great question, and you and Mr. Bridges are going to end up talking about that. But what he has shared with me is an important reason for us to not do anything today. If you have even 3 other cases coming down the pipeline, we need more information, about what all is going on, because what you don't want is, oh, let's put him on house arrest, and then you're indicted for another burglary and you get rearrested, and then you're out and you get rearrested. If in fact there are these other cases out there, and I'm not saying there are, but Mr. Bridges sure thinks there are, and he has no reason to be mistaken about that, then we need to figure out what's happening with those. Now, we need to strike a balance. If what I hear from the state is, you know what, we're not going to be able to charge those for months and months, then those shouldn't bother us right now. And we should look at the 2 cases that have been charged. Those are very real now. But if what I learned from Ms. Hall is, you know, they're going to be indicted, there's a grand jury that starts in just a few weeks. If that grand jury is going to be considering those cases, then we need to wait for that. And if you're dealing with 8 burglaries instead of 1, that's a different conversation about house arrest or bond or something like that. And it's only fair to everyone involved, including you, that we get all that information out there. So it's going to be a little while longer. My commitment to you and your family is that we'll set a date certain to get everyone back together, whether it's in person or on a Zoom call, where you'd be coming in from the jail. So you'd be on a screen at the jail to figure out what's happening with those 6, 7, or 8 other cases. And as I said, if the answer is nothing's happening for a long time, then we need to talk about bond. If they're going to be charged right away, or you and your lawyer decide, let's just let them accuse those cases, and Mr. Bridges can explain what that means, then what we may be talking about is how do we resolve them? Because of course, that's the end game here, is how are they resolved? Is the state dismissing them? Are you pleading? Or do you want a trial? And it's a bunch of cases. So it's going to take a little while to sort through all that. Does that make sense?
Kinda, not really.
Well, I'm happy to explain it more. What I'm not asking is, are you happy with that answer? Because I know you're not. You'd like to get out. I appreciate that. But if you've got 7 unindicted burglaries rattling around out there, I'm not going to give you a bond. I need to figure out what's going on with those. And I need to give Ms. Hall, who maybe is just learning the fact that there are all these other burglaries, a chance to see what's the DA's office going to do. If they're going to move slowly, that's not your problem. And we'll talk about bond on just these 2 cases. But if they're able to move quickly, then we really ought to talk about all 9 cases you have, or whatever the number ends up being, rather than just these 2, because these 2 are not an accurate picture of what's going on for you if there are all these other cases. Were you surprised to hear from Mr. Bridges that you might have a few other cases out there? Or you were aware?
I was aware. I see it on my paperwork.
Okay, so that's, I don't want you to talk about the substance, but that didn't shock you to hear, hey, there may be some other charges out there.
Yeah, it was shocking. It was actually like under one roof, a storage facility.
Okay, well, let's not talk about it. And it may be that the way this ends up moving forward is it becomes one case. But I'm gonna let you and Mr. Bridges talk about that. He knows how to contact you at the jail. More importantly now, Ms. Hall knows how to contact him. And so your lawyer and the prosecutor can start talking about what's the most effective way to move all your pieces of, all your cases along, okay?
Okay.
So we'll see you soon, whether we talk about bond or not, to be determined. It really depends on what's happening with those other cases.
Okay.
Now your aunt has a question. Yes, ma'am. Sure.
So, we have some concerns as a family, because in December the 9th, when we first came to court, Terrell Dark was the attorney, and he told us that he sent the papers to Attorney Bridges in December. When we spoke with Attorney Bridges, my mom spoke to him, I spoke to him, my sister spoke to him, and in December, he had said he had just gotten the case and that he would look at it. And so we have been calling him consistently up until this time. And I even wrote you a character letter for my nephew. I even wrote him a letter too as well about the court today, the time, and to see if we could either be present or not be present. The communication has not been that well, but he did assure us in December to call him the first of the year. He will give us all the information on whether to be sentenced or the bond. And I personally emailed him all the information on my nephew, which was some of those charges was the same charges about the burglary that was, some years. But we wanted to get some information with the communication. So we just had some concerns because of the lack of communication and because of the information that was presented to us in December. And then we have been consistently calling. And I don't know about the law, so I don't know if he could get another appointed, a public defender or offender. I'm not really sure.
Okay.
But he's been incarcerated since October, and it's now February, and it's COVID. I don't know if that's taking effect, but I don't know if we have if we're in a position to request for a new public defender.
So a couple things. One, your nephew has a good lawyer right now who is working hard on his behalf. Mr. Bridges' primary obligation is to your nephew and not to you. And that's not to say Mr. Bridges wouldn't talk to you or shouldn't talk to you. He will, and I suspect he will now that we've had this conversation. But until Mr. Reed was back in court, there was only so much Mr. Bridges could do. And it also sounds like until the district attorney's office decides what they're going to do with however many other cases there are, there's not a whole lot Mr. Bridges can do. He could come in here next week and say, you need to give my client a bond. And the prosecutor could say, well, Judge, you should know that there are 7 unindicted burglaries for Mr. Reed. My response to that probably would be, well, I'm not going to give a bond right now, but I'll give the state X number of weeks to figure out what are they going to do with those unindicted burglaries. And as I've told Mr. Reed, if they're not going to do anything, then we don't worry about them anymore. But there has not been a grand jury in place to indict those burglaries. It's not Mr. Reed's fault, but it's also not the district attorney's fault. But a grand jury is coming back into session. So the state's not going to be able to say, well, we really can't indict anything because we don't have a grand jury. They're going to need to either make those charges official or set them aside. If they make them official, I think you can understand, I hope you can understand why bond is a different question if we're talking about 5, 6, 7 burglaries. I don't know anything about them. And it may be that it's really not as bad as it looks. And it's a bunch of burglaries on the same day. It's one, if you go into a hotel and you break into 5 hotel rooms, is that 5 burglaries or is it 1? I don't know. We will. And of course, your nephew is presumed innocent of all this stuff, which is why bond is even a possibility. But Mr. Bridges is entitled to get the information from the state. And the state doesn't necessarily have information to give until that grand jury is in place. So I hear your frustration, both with how slowly things are moving for your nephew and how maybe you aren't connecting as often as you want with Mr. Bridges. But he's working hard on behalf of your nephew. And I'm going to encourage him to reach out to you after today to give you his sense of where things are going next. But again, his client is Mr. Reed and not you. And so as he's prioritizing things, if he has a client calling saying, you need to call me back, then he's got the aunt of a client, he's probably going to call the client back. He's not your lawyer. And that's not to say he's your opponent or anything like that. Perfectly nice guy. And he will make time to interact with you, but it's not every day he can be reaching out to the family members of all the clients. And that's not what you're asking for. You're just saying, tell me something, and we'll try to make that happen. Okay. All right, Ms. Hall, if you would please figure out what your office is planning to do with these other cases. I'll get with Ms. Nelson. We'll set this out to give you time to do that. It won't be next week. You'll have a little while to work through it. And then please do talk with Mr. Bridges, because depending on what you can share with him about those cases, he may decide it's in his client's best interest to have those be accused rather than indicted, in which case we accelerate the whole process. But that's ultimately a conversation for the two of you, a decision for Mr. Reed, and then the state will do what it's going to do.
Yes, Your Honor.
So, Mr. Bridges, we will look for a waiver of arraignment for Mr. Reed in the 2 cases that are on today's calendar. Do you need Ms. Nelson to email you that form?
Yes, Your Honor.
Okay, we'll get Ms. Nelson to email you the waiver of arraignment form. If you'll fill that out and e-file it, that'll take care of the two positions today. And then we'll get these two cases on a status calendar a little ways out to get an update, not on these two cases, but on all the others to see how quickly they're going to catch up with these. And that may be a time when we talk about bond, if what you've learned, Mr. Bridges, is that there's no light at the end of the tunnel for those other cases.
Yes, Your Honor. Thank you.
All right, Ms. Hall, anything else in Mr. Reed's cases?
Nothing further from the state.
Mr. Bridges?
No, Your Honor.
All right, thanks for dialing in. Mr. Reed, we will see you soon once we figure out what's going on with those other matters.
Thank you, Your Honor.
Thank you both for being here and for being here on behalf of Mr. Reed. All right, Ms. Hall, it was great to see you in person.
I see you too.
Your bond